Welcome back to Enchanted Learning. It's me, Benazir Khalid. Today we are moving to the topic Consumer Protection Act 1986, and here we are discussing about more examples related to this topic. It can be asked in a wide way, so please listen to the above examples and the rules regarding these. Consider these examples. Shall we move to the topic?
Okay, let's move to the next point. We were discussing about Consumer Protection Act 1986. Intention of legislature. Intention of legislature. The intention of legislature is to exclude big business houses carrying on business with profit motive from the purview of the act. At the same time, it is pertinent to save the interest of small consumers who buy goods for self-employment to earn their livelihood, like a rickshaw puller buying rickshaw for self-employment, or a farmer purchasing fertilizer for his crops, or a taxi driver buying a car to run it as a taxi, etc. So the intention of legislature, this act is meant to exclude big business houses carrying on business with profit motive. So the intention of legislature is to exclude those persons who carry out business with the profit motive, and at the same time it is meant to save the interest of small consumers who buy goods for self-employment, that is for their own livelihood. For example, a rickshaw puller buying rickshaw for self-employment, a farmer purchasing fertilizer for his crops, whereas a taxi driver buying a car to run it as a taxi, etc. Let us move to an example. A was running a small type institute to earn his livelihood. He purchased a photocopy machine Canon NP150. It proved defective. He sued the seller who contended that A is not a consumer under the Act as he purchased the photocopier for commercial use. The Commission held that by no stretch of imagination it can be said that the photocopier would bring large-scale profits to A. It was a part of a small-scale enterprise. He was construed as consumer under the Act. So in this example, A was running a small type institute to earn his livelihood. And for that purpose, he purchased a photocopy machine and it found to be defective. He sued the seller who contended that A is not a consumer under the Act as he purchased the photocopier for commercial use. So, as a photocopy machine was purchased for his livelihood. So, the consumer commission said that the photocopier was meant for his small scale in the enterprise. So, that is not providing large scale profits to A. So, he can be considered as a consumer under this act. However, if such a buyer takes assistance of two or more persons to help him in operating the vehicle or machine, etc., he does not cease to be a consumer. So, if a buyer takes assistance of two or more persons so as to help him in operating such vehicles or machines, etc., he cannot be called as a consumer. If he uses that particular machine or vehicle for his own livelihood, he can be considered as a consumer. Whereas if he is taking the assistance of two or more persons, then he can't be considered as a consumer as per the act. Examples: A buys a truck, plates himself, and hires a cleaner who accompany him all the time and at times drives also when A is busy otherwise. Then A is a consumer. That means if A buys a truck and he himself uses it and he also accompanies a cleaner who helps him in all sorts of and who helps him in all the time, and sometimes he also drives when A is busy. Here A is using the truck for his livelihood. So he can be he is accompanying a cleaner is accompanying him for only to uh, for his assistance, only to provide assistance, or only to give assistance. That means A is accompanying a person accompanies A only to help him. So that means A is himself A himself is a consumer. A can be considered as a consumer because A is using by using the truck for his own livelihood. The second example, P, an eye surgeon, purchased a machine from R for hospital run by him. The machine was found to be defective one. R contend that P was not a consumer under the Act as the machine was bought for commercial purpose. The National Commission rejected this contention and held that P is a medical practitioner, a professional working by way of self-employment by using his knowledge and skill to earn his livelihood. It was not proved by any evidence that P is running a huge hospital. Thus, the purpose of purchase of machinery is in the nature of self-employment. Rampion Pharmaceuticals versus Dr. Preetham Shah, 1997, ICPJ 23, NCDRC. Here the second example, P, an eye surgeon, purchased a machine from R for the hospital run by him. So P was an eye surgeon. He purchased a machine from R for the purpose of for hospital run, and this machine was found to be defective. Then R contend that when this machine was found to be defective, when when P asked R to rectify the defect, then R contend that P was not a consumer under the Act as the machine was bought for commercial purpose. But National Commission rejected this contention and held that P is a medical practitioner and he, by means of self-employment, he used for the by way of self-employment, he uses his knowledge and skill to earn his own livelihood, and he is no and it was proved by an evidence that P is not running a huge hospital. So the purchase of this machinery is in the nature of self-employment. So he purchased machinery for the purpose of self-employment. So in this context, he can be considered as a consumer. Consumer of services. A person is a consumer of services if he satisfies the following criteria. Services are hired or availed of. The term hired has not been defined under the Act. Its dictionary meaning is to procure the use of services at a price. Thus, the term hire has also been used in sense of avail or use. Accordingly, it may be understood that a consumer means any person who avails or uses any service. That means consumer of service. A person is a consumer of service only he satisfies the following criteria. Services hired or availed of. The term hired is not defined under the Act, but its meaning is to procure the use of service at a price. At a price, the use of service is to be procured. That means that is what meant by hire. Then hired is also used in a sense avail or use. So it may be understood that a consumer means any person who avails or uses any service. Example, A goes to a doctor to get himself treated for a fracture. Here, A is hiring the service of the doctor. Thus, he is a consumer. What constitutes hiring has been an issue to be dealt with in many consumer disputes. If it is established that a particular act constitutes hiring of service, the transaction falls within the net of Consumer Protection Act and vice versa. That is, if a particular act comes under the hiring of service, then that transaction can be included within the Consumer Protection Act. For example, a passenger getting railway reservation after payment. A passenger getting railway reservation after payment is hiring service for consideration. A landlord neglected and refused to provide the agreed amenities to his tenant. A landlord neglected and refused to provide the agreed amenities to his tenant. He filed a complaint against the landlord under the Consumer Protection Act. Here, the National Commission dismissed the complaint, saying that it was a case of lease of immovable property and not of hiring service of the landlord. Srimati Lakshmi Ben Lakshmi Chand Shah versus Srimati Sakir Ben Kanji Chandan, 1992, 1 COMP LJ 177 NCDRC. So, in the second example, a landlord neglected and refused to provide agreed amenities to his tenant. Then the tenant files a complaint against the landlord under the Consumer Protection Act, but the commission dismissed the complaint since it was a case of a lease of immovable property, and here it is not meant with the hiring service of, it is not related to the hiring service of landlord. Third example, A presented before the sub-registrar a document claiming it to be a will for registration, who sent it to the collector of stamps for action. A presented before the sub-registrar a document claiming it to be a will for registration, who sent it to the collector of stamps for action. The matter remained pending for about 6 years. In the meantime, A filed a complaint under the Consumer Protection Act alleging harassment by the sub-registrar and collector and prayed for compensation. Here, the National Commission held the view that A was not a consumer under the Consumer Protection Act because there was no hiring of services by the complainant for consideration, and because a government official doing his duty as functionary of the state under law could not be sent to be rendering a service to the complainant. SP Joel versus Collector of Stamps 1995, 3 CPR 684 SC. That means A presented before the sub-registrar a document claiming it to be a will for registration, and that was sent to the collector of stamps for action. And sub-registrar sent it to the collector of stamps for action, but the matter remained pending for about 6 years. In the meantime, A filed a complaint under the Consumer Protection Act against the sub-registrar and the collector and prayed for compensation, but the National Commission held the view that A was not a consumer under the Consumer Protection Act because there was no hiring of services by the complainant for consideration. Here, a government official doing his duty as functional state under law cannot be said to be rendering a service to the complainant. Consideration must be paid or payable. Consideration is regarded necessary for hiring or availing of services. However, its payment need not necessarily be immediate. It can be in installments. For the services provided without charging anything in return, the person availing the service is not a consumer under the Act. So here, consideration must be paid or payable. That is, consideration is regarded necessary for hiring or availing of services. That means that payment is not necessary to be, or it need not necessary to be immediate. It can be made paid in installments. That means for services provided without charging anything in return cannot be that is, services provided without charging anything in return, then the person availing that service cannot be considered as a consumer under the Act. So only when consideration must be paid or payable. That means consideration is regarded for hiring or availing of services, and that can be made in installments also. Example: A hires an advocate to file a suit for the recovery of money from his employer. He promises to pay fee to the advocate after settlement of the suit. A is a consumer under the Act. Here, A hires an advocate to file a suit for recovery of money from his employer, and he promises to pay fee to the advocate after the settlement of suit. So here, consideration is promised for hiring or availing of service. So A is considered as a consumer under the Consumer Protection Act 1986. A goes to a doctor to get himself treated for a fracture. The doctor, being his friend, charged him nothing for the treatment. A is not a consumer under the Act. Here, A goes to a doctor and gets himself treated for a fracture. Here, doctor, being a friend, charged him nothing for the treatment. So here, for the services provided without charging anything in return, the person availing the service is not considered as a consumer under the Act. So that is what mentioned here. A is not a consumer under the Act. Third example, B issued an advertisement that a person could enter the contest by booking a Premier Padmini car. S purchased the car and thus entered the contest. He was declared as winner of the draw and was entitled to two tickets from New Delhi to New York and back. S filed a complaint alleging that the ticket was not delivered to him. The National Commission held that S was not a consumer in this context. He paid for the car and got it. B was not liable so far as the contract of winning of lottery was concerned. Balfour vs. S.S. Srivastava 1993 2 CPR 83 NCDRC. B issued an advertisement that a person could enter the contest by booking a Premier Patni car. And S purchased the car, thus entered the contest. And he was declared as a winner and he was given two tickets from the New Delhi to New York and back. If S filed a complaint that the ticket was not delivered to him, but National Commission held that S was not a consumer in this case because he paid for the car and he got it. And this B was not liable in the case of contract of that is related to winning a lottery. As far as winning a lottery is concerned, B is not liable in this contract. That means the direct and indirect taxes paid to the state by government is not payment for services rendered. Here, the direct or indirect tax paid by the state, paid to the state by a citizen is not considered as a payment for services rendered. Next example, T was paying property tax for his house to the local corporation. He was paying property tax for his house to the local corporation. This corporation was responsible for proper water supply to the premises under its work area. T raised a consumer dispute over the inadequacy of water supply by the corporation. The National Commission held that it was not a consumer dispute as water supply was made by the corporation out of its statutory duty and not by virtue of payment of taxes. By T. Mayor, Calcutta Municipal Corporation vs. Tarapada Chatterjee 1994 1 CPR 87 NCDRC. That means here in this example, T was paying property tax for his house to the local corporation and the corporation was responsible for the proper water supply to the premises under its work area. And T raised a consumer dispute over the inadequacy of water supply with the corporation. National Commission held that it was not a consumer dispute as the water supply was made by the corporation out of its statutory duty and not by virtue of payment of taxes. Here, next one. Beneficiary of services is also a consumer. Beneficiary of service is also a consumer. When a person hires services, he may hire it for himself or for any other person. It means when a person hires service, he may hire it for himself or he can hire that service for another person or for any other person. In such cases, the beneficiary or user of this service also a consumer. As you mentioned in the above, as we mentioned the definition of consumer, there we have mentioned that when a person hires services, if we hire it for himself or for any other person, he can be considered as a consumer. For example, A takes his son B to a doctor for his treatment. Here A is a hire of service to doctor and B is a beneficiary of this service. For the purpose of the act, both A and B are consumers. Here A is the person who hires the service of doctor and B is the beneficiary. So from the above case, when a person hires service or he may hire for it himself or for any other person, he can be considered as a, that means both A and as well as B can be considered as a consumers. Note, this is an exception to the rule of privity to the contract. So it's an exception to the rule of privity to the contract. Note that in case of goods, buyer of goods for commercial purpose ceased to be a consumer under the Act. On the other hand, a consumer of service for commercial purpose remains a consumer under the Act. Here, in case of goods, buyer of goods for commercial purpose ceased to be a consumer under the Act. That is, a buyer of goods who buys those goods for commercial purpose cannot be considered as a consumer under the act. But if on the other hand, if consumer of service for commercial purpose, the consumer provides service for commercial purpose, then he can be remained as a he can be considered as a consumer under the act. For example, S applied to electricity board for electricity connection for a floor mill. There was a delay in releasing the connection. S made a complaint for deficiency in service. He was held a consumer under the act. Here, Shamshar Khan versus Rajasthan State Electricity Board 1993, 2 CPR 6 Raj. In case of goods, buyer of goods for commercial purpose ceased to be a consumer under the act. On the other hand, if the consumer is provided for service, consumer of service is for commercial purpose, then it means he can be remained as a consumer under the act. Here S applied to electricity board for electricity connection for a floor mill. When there was a delay in releasing the connection, he made a complaint for deficiency in their service. So the service is provided to yes, as he was treated as a consumer under the act. Okay, in this example, S applied to electricity board for electricity connection for a floor mill. That means S applied, he provided an application to the electricity board for electricity connection for a floor mill, and then when there is a delay in releasing the connection, he made a complaint for deficiency in service. Then he can be considered as a consumer because he has he is going to run this floor mill for his own livelihood. So he can be considered as a consumer under the act. Here he provides the service. That service is meant provided by him, and that he is considered as a consumer because he is providing this service for his livelihood. So he can be considered as a consumer under this act. I hope you all understood today's topic. Wait for the coming videos. Please do share, subscribe and like and comment the video. Thank you.